Well, good morning, everybody. It's 9:30 and the inquiry is resumed. My name is Guy Davis. I'm invited to hear the appeal that has been brought by Retirement Villages Developments Limited against the decision of Surrey Heath Borough Council for a mixed residential development on land at Snows Ride in Windlesham. We're entering the last day of the inquiry. Before we do that, can I just mention the normal housekeeping matters? If you have phones, please set them to silent, ditto with laptops. If there is a fire alarm, we'll treat it as real. Please leave the building by the signed exits and congregate in Knoll Road car park. I completed a site visit yesterday afternoon. I had a good look at the site. I went onto the site. I walked all of its boundaries and a little outside as well. Don't have any questions, I don't think, arising from that. Well, I say I don't have any questions. I was intrigued as to why there was a dinosaur with artificial grass on it sitting near the barn. How extraordinary with the things you see on site visits. Fantastic. Okay. Well, it was lovingly covered by like a horse rug or something, I think. So somebody likes it. I have seen a revised list of conditions, so thanks for that. I've had a quick look at it this morning. Certainly the condition that condenses the highway issues seems to me to be a lot better. So I'll look at that in more detail in due course, but I think it's got where I wanted to get to. Section 106, there was going to be another clause added. Can you update me on that one?
So there have been discussions overnight with both the County Highways Authority and also with the Planning Authority. What's currently proposed, and apologies because we are going to amend the schedule of conditions that you have just got, is to split the restriction on occupation and put that back into the condition to deal with the scheme and the making of the order, and to put in the 106 agreement an obligation to meet the costs of the traffic regulation order, right, so that all the highway matters are dealt with in conditions.
So I'm expecting to see another condition at some point.
That's exactly right, yes, and we'll share that with you later this morning.
Okay. I think that is all the housekeeping I have. Anything from either side? Yes. Thank you for that. Has a copy gone to the council?
Electronically, I think. Electronically, okay. But there's a spare one there.
Thank you. So this was the 2012.
2012.
Yeah.
Yes, I haven't checked for all subsequent iterations.
All right. Okay, thanks for that. Good. Anything from the council side? Okay. In which case, I think then we can move to the main business of today, which is to hear closing submissions on behalf of the main parties. As is tradition, we will start with the council first. So, Mr. Atkinson, over to you. Thank you.
So, it's common ground that the proposed development would utilise grey belt land, but but would not meet the golden rules because of an inability to meet the affordable housing requirements of the framework 156 and 157. And at the footnote, I set out the numbers. The proposals are therefore agreed to be inappropriate development, and in order for permission to be granted, it needs to be demonstrated that very special circumstances exist such that the harm to the greenbelt resulting from harm to openness and any other harm resulting from the proposal is clearly outweighed by other considerations. The Council's case is that the tilted balance is disapplied in this case. The tilted balance is framework paragraph 11D2, not paragraph 11D as a whole. And this is commonly misunderstood. In this case, it is agreed that the development is inappropriate development and may only be permitted if VSCs are found to exist under the Framework 153. It is accepted that the relevant development plan policies that are most important for determining the application are missing or out of date by virtue of footnote 8. So permission should be granted unless the application of any of the footnote 7 policies provide a strong reason for refusing permission. This is what 11D1 says. Greenbelt policies are, of course, a footnote 7 policy. The Council's case is that the application, and I set out there the authority for this proposition, which is a case of Monk Hill, which was in the High Court and then the Court of Appeal. You'll be familiar with it. The application of Greenbelt policies in the framework do provide a strong reason for refusing permission. Monk Hill confirms that because the application of some footnote 7 policies under 11D1, specifically Greenbelt, requires consideration of all relevant planning considerations and will therefore provide an answer to whether to grant permission or not, there is no need to then go on to consider 11D2, the tilted balance. Only if the answer to the question posed by 11D1 is that the application of footnote 7 policies do not provide a strong reason for refusal, may the decision maker then go on to consider 11D2, the tilted balance. In simple terms, the consideration and judgment of all the argued for VSCs in this case will provide you, sir, with an answer whether to grant permission or not, and the conclusion should be that permission is not granted. Dealing then with the issues as identified in the CMC, the effect on the openness of the Greenbelt first. In respect of openness, it is noted at the outset that the landscape sensitivity assessment observes that the appeal site, the fields east of the settlement, are more visually open than the remainder of the sub-area, SS6A, within which the appeal site sits. The substantial negative weight Ms. Fitzpatrick attributes overall to the impact on openness of the Greenbelt at the appeal site is correct. Whilst it is accepted that the site is well contained by trees and planting, it is not entirely enclosed from view. Both spatially and particularly visually, the development of what is currently a completely open field with development of up to 2.5 stories in height, together with all the attendant movement, would inevitably considerably reduce the site's openness. Notwithstanding the sizable sang element, this would have a permanent conspicuous urbanising effect. Ms. Fitzpatrick accepted that the impact on the visual aspect, that's the spatial aspect, the spatial aspect, correct that, of openness is moderate, essentially because of the extent of the appeal site, which would remain open as sang. Although there is a trade-off between the two elements of openness in this case, the effect of the sang is to concentrate development into roughly half of the site to its north and west, which, while reducing the impact spatially, increases the impact visually. This is reflected in Ms. Fitzpatrick's main concern, which is rightly, in respect of the visual aspect, the impact on which would be significant, particularly from the south and west, from Snows Ride itself, and through the vehicular access there, which is not shown on Mr. Hammond's zone of theoretical visibility plan, nor is the access from the A30, as well as through the many existing gaps in the vegetation along this boundary. This impact on the visual openness is evidenced by the verified viewpoints Mr. Hammond produces, particularly when the opaque bulk of the development, signified by the red wire lines, is borne in mind. Mr. Hammond agreed the visual impact of the development is much greater as perceived by people moving east along the A30 towards Sunningdale and around the junction of the main road and Snow's Ride. In addition to openness, the development of the appeal site as proposed would have a significant impact on purpose C of Framework 143 to assist in safeguarding the countryside from encroachment. The contribution of the site to this element has been significantly underplayed by the appellants. Simply put, and as accepted by Mr. Hammond, nothing has changed since the 2022 Greenbelt Review found that the appeal site, which coincides almost exactly with the parcel of land there assessed, SR9, functions strongly in respect of openness and purpose C. The 2022 study found of SR9, the parcel possesses the characteristics of the open countryside, principally comprising 2 large fields. Although 2 residential dwellings are situated to the southeast of the parcel and do have a localised impact upon openness, this area is small in scale, and as such it is not considered that these undermine the overall performance of the parcel. The only localised impact on openness within parcel SR9 noted in 2022 arose from the 2 residential properties situated to the southeast of the parcel. These properties do not now fall within the red line of the development proposals. Therefore, such as there was any localised impact on openness within SR9, this has now been removed from the appeal site. What the 2022 review means by functions strongly is as set out here. The land parcel possesses the characteristics of the open countryside and exhibits a significant degree of openness. Development will generally be limited to buildings and uses otherwise expected in the countryside, with little or no urbanising development. There is little or no sense of urbanising influence from neighbouring land. This generic characterisation of a parcel of land functioning strongly according to the terms of the 2022 review, as set out above, serves as a remarkably apt description of the appeal site itself. The 2022 review upgraded the harm to purpose C to strong from moderate, which had been the finding of the 2018 site appraisal. Clearly exercised by this difference, the 2022 review, went so far as to set out the reasons for having reached a different conclusion than that of the 2018 site appraisal. And this was because the urbanising factors, the surrounding development in the A30, were adjudged to have been overstated in 2018. The appellant's analysis makes exactly the same mistake now and overstates the urbanising influence of the A30 and the surrounding development so as to seek to diminish the impact of the proposals on purpose C in the absence of any other change. It is notable too that Mr. Hammond readily accepts and relies on the findings of the 2022 Greenbelt Review to assist him in determining the contribution of the site to purposes A and D as part of the grey belt exercise, but rejects them significantly in respect of purpose C. It is in light of this that the considerable extent of the proposed development of this parcel is considered to cause significant harm to purpose C. Ms. Fitzpatrick is correct to reject the notion that no harm to purposes A, B, and D can amount to a benefit. It is neutral. In respect of the impact of developments on purpose C, encroachment, Mr. Hammond introduces the concept of inherent countryside, which he was not able to explain. It therefore remains unclear what this means beyond development that, whilst taking place in an otherwise open field in the open countryside, does not amount to encroachment of it. The 22 study found the appeal site to possess the characteristics of the open countryside, and nothing has happened to it since. that assessment to justify recharacterisation now as inherent countryside, whatever that is. It is notable that the appellants have sought to challenge the appeal site's status as countryside, Mr. Hammond going so far as to say that the site is not countryside at all. However implausible these challenges are, and they are implausible, it may be that there is within the challenge a tacit acceptance that the land is being encroached upon by the proposed development. Because this cannot be denied, the appellants attempt to recharacterise the land as not countryside. Mr. Henderson then repeats the faulty analysis that inherent countryside appears not to be countryside at all. It is said that the roads and existing housing nearby render the appeal site not countryside, rather urban land, which can consequently be developed without causing significant harm. This analysis is not plausible, nor is the appellant's characterisation of it as peri-urban. The open countryside found by the 2022 study has been refined by the officer report to semi-rural in character, but this would be transformed by the proposed development to an essentially urban character as a result of the concentration of development towards the north and west of the side, necessitated by the location of the Sang. Mr. Henderson seeks to argue also that Greybelt is itself by definition more able to accommodate change to openness, spatial and visual, than other land in the Greenbelt. This is not correct. Paragraph 142 reminds us that the fundamental aim of Greenbelt is to prevent urban sprawl by keeping land permanently open. The essential characteristics of Greenbelt are their openness and their permanence. This aim, which applies to all Greenbelt land, is distinct from the 5 purposes set out at para 143. There is nothing to suggest that not making a strong contribution to purposes A, B, or D has a bearing on openness. In any event, the aim of Greybelt policy may not be disaggregated in this way. As Mr. Henderson states, national policy deems Greybelt to be suitable for development in certain circumstances, those circumstances being provision of infrastructure, public open space, and affordable housing. Greybelt land is Greenbelt land which may be suitable for development for those specified purposes. If, as in this case, one of those circumstances, affordable housing, is missing, its freestanding attributes as Greybelt may not be relied on, and certainly not in respect of openness. Mr. Henderson's assertion that the degree of activity would be relatively low compared to the proximity to the A30 and the nearby residential land use is not credible. The activity on the A30 and from nearby residential would remain as previously, but added to that would be the comings and goings or activities of a further 187 households, potentially a doctor's surgery, as well as Sang users from within 400 metres on what was previously an undeveloped field. The framework tells us that substantial weight must be given to any harm to the Greenbelt, including harm to its openness. It is agreed that substantial harm must also be given to harm to purposes, in this case, harm to purpose C. Ms. Fitzpatrick is correct, however, to reject the suggestion that not harming the other purposes, A, B, and D in this case, can amount to a benefit. In the end, Mr. Henderson agreed with this, noting in his evidence that the relevance of Greybelt showed on the harm side of the balance. The effect on the character and appearance landscape of the surrounding area. The appellant's exception to Ms. Fitzpatrick's description of the site as possessing relative tranquility raised in opening is surprising. The landscape sensitivity assessment refers to a loss of tranquility, but that is clearly a reference to land to the north of the A30 rather than the appeal site, which is to the south of the main road. The characterisation of the landscape of the sub-area in the same paragraph notes the sub-area is characterised by pastoral fields and paddocks set within woodland, although interspersed with some existing built development and associated road infrastructure. Taken together with the observed overstatement of the urbanising influence of the built development and road set out in the Greenbelt Review of 2022, and the odd shape of landscape sensitivity study parcel 6, SS6A, comprising an amalgam of sites described accurately in the title of that parcel, settlement edges north and east of Snows Ride. It is reasonable to consider the starting point to be, as Miss Fitzpatrick describes the appeal site, as essentially a transitional place between the built-up and open countryside. Flowing from these studies, Miss Fitzpatrick's assessment of the character and appearance of the site must be right. She finds that the character of the site is semi-rural, serving as a transitional place. And I note the footnote that, interestingly, this is the same way in which Mr. Henderson explained yesterday to you, sir, what he meant by peri-urban, in the sense of the appeal site acting as a transitional space between the more developed to the west and less developed to the east. Back to the paragraph 31. Transitional place between the built-up area immediately to the west across Snows Ride and the undoubtedly open countryside to the east. This transitional character is emphasised by a visual separation too between the residential enclave bounded by Snows Ride, London Road and School Road to the west and the open countryside to the east. It is the separation of the appeal site from the residential areas described by the roads mentioned which gives it its semi-rural character currently. Development as a housing estate, essentially, would be fundamentally different in character and appearance to the current semi-rural plot used currently for horse grazing, a distinctly pastoral and tranquil activity contributing to character which would be entirely changed. Mr. Hammond accepts that there will inevitably be a change in the character of the appeal site flowing from its development as an undeveloped area to one of new built form with all associated movements, etc. He describes this as major adverse at year 1, reducing to moderate adverse at year 5. Ultimately, it appears there is not a great deal of difference between Miss Fitzpatrick and Mr. Hammond on character and appearance, and such difference as there is may be more a function of the area over which the impact is assessed and the different nomenclature used. Mr. Hammond's analysis overall is set within a radius of 2 kilometres of the site. He focuses down onto the appeal site by identifying 8 local landscape character areas, LLCAs, surrounding the site for which the effects on the landscape are assessed according to a 5-point scale, and the scale is set out at the footnote there. Of these LCAs, 4, 3A Snows Ride Residential, 3B Snows Ride Road, 4 Snows Ride Field, the appeal site itself, and 5 Windlesham Court can sensibly be considered to represent the surrounding area referred to in the reason for refusal. In this way, the development areas considered by Ms. Fitzpatrick and Mr. Hammond may be sensibly compared. Comparison of the different nomenclature used by Mr. Hammond, who discusses landscape effects, addressed in the reason for refusal, which does not mention landscape, and Ms. Fitzpatrick, who addresses character and appearance, is possible by analysing the different scoring scales used. What that comparison shows is that Mr. Hammond's assessed impact of the foremost immediate LLCAs equating to the surrounding area are at level 1 of 5, LLCA 4, level 2 of 5, LLCA 3B, and 3 of 5, LLCAs 3A and 5, all after 1 year. These weightings taken together compare broadly to Ms. Fitzpatrick's assessment of the harm to the character and air of the surrounding area being significant, which is the second highest level of harm on the agreed scale used by her. The harm to the character and appearance of the surrounding area should for these reasons be given significant adverse weight in the balance. There does remain a tension in the appellant's case, however, between visual impact and landscape character. On the one hand, for the purposes of assessing visual impact on the visual aspect of greenbelt openness, reliance is placed on the thick existing boundary vegetation, particularly along the A30, which encloses and contains the site visually, limiting its visual impact, it is said, to the immediate proximity. The boundary vegetation cannot essentially be seen through. Yet, on the other hand, it is argued that the urbanity of the main road and the nearby residential development permeates the site boundary so as to allow the site not to be considered as countryside at all. The boundary vegetation is for these purposes permeable. Whether very special circumstances, focusing on areas of disagreement only, the Council accepts that the supply of specialist housing, in this case the IRC, should attract substantial positive weight in the balance, but that the additional weight to the absence of a pipeline or policies should attract only moderate weight. This is exactly the same weight given to these aspects in the officer report. The reasons are the same as in the officer report too. There is a policy in the emerging local plan, H6 specialist housing, which encourages housing for older people plus 2 allocations for this. There clearly is a pipeline and policies for age-specific housing shortly to come into effect upon adoption of the emerging local plan. And for this reason, the additional weight for the absence of such should only be moderate, which fairly reflects the absence now. Affordable housing. The provision of affordable housing exceeds the policy requirement for the conventional C3 units. The policy requirement in numerical terms is for 40%, and the proposals are now for 70%, 23 of the 33 C3 units to be provided. However, the policy requirement is also for the affordable element to be split evenly between social rent and intermediate housing, essentially shared ownership. And paragraph 30, so I address the different definitions. I set out the current one. And none of what is proposed to be provided as affordable housing in this case comes within either of these categories. It is all proposed to be discounted market sale. Actually, sorry, so I should just draw your attention to the final paragraph of the footnote 30, where, having set out the current definition, it is accepted that DMS as offered could come within the definition of other low-cost homes within the current definition. CP5 does not specify that individual sites must each provide the split, although clearly that is implied by the policy. But there is no reason advanced by the appellants why the policy split should not apply to the appeal site until Mr. Garside gave evidence. He candidly admitted that the reason for the proposed provision of forms of affordable housing that are not policy compliant is because the developer cannot find a registered provider that is interested in taking on a handful of houses on their own, as the management costs of these would be excessive. Mr. Garside went on to explain that registered providers prefer bigger sites, and those that are building at all are tending to develop their own sites, and this situation is likely to persist for the next couple of years. At risk of adding to the number of hypothetical other schemes that have already been raised during this inquiry, it may have been better for the developer here to have been candid about the lack of registered providers' interest sooner. This may have justified a sum in lieu of on-site affordable housing, which could have been used to provide forms of affordable housing in accordance with policy CP5 elsewhere. Provision of only DMS represents a further breach of policy CP6, which generally expects intermediate and social rented units in accordance with the SHMA or other subsequent assessment. In the absence of evidence of housing need or viability, CP5 allows for viability evidence too. Viability evidence in this case has been provided, but this concludes that the scheme is deliverable with the level of affordable housing offered, notwithstanding that the affordable housing offer is in excess of policy requirements in numerical terms and the very low profit margins expected. And the footnote there notes that Mr. Garside was equally candid about the level of affordable housing to be provided, calculated as it was in order to advance the appellant's VSC case as best as possible. The Council's policy preference for social rented and intermediate housing is because the people that these forms of affordable housing are aimed at are in the greatest need and are generally unable to raise a mortgage to buy any property at any price. Ms. Fitzpatrick's explanation of this point in her proof remains valid, despite it being based in her proof on the previous 2020 housing needs assessment rather than the more recent 2024 version. In a high-cost area such as Surrey Heath, DMS assists people who are likely to be able to just afford market housing already, but it does nothing for those who could not afford a property, regardless of the extent of the subsidy. Simply put, if you cannot get a mortgage at all, no amount of subsidy is going to help. The people who cannot get a mortgage, likely to be on benefit and with poor credit rating, would never be able to muster a mortgage to own a property, regardless of the extent of any subsidy. And it is in order to provide for this group of people that the policy seeks social rented housing. This form of housing essentially requires the involvement of a registered provider. It is these forms of affordable housing that better meet the needs, the actual need in Surrey Heath, and which are consequently sought in policies CP5 and CP6. It is not accepted that the large subsidy on a handful of houses, a discount of 70% below market value on 11 units and 40% below market value on a further 12, is the equivalent of social rented or intermediate housing as required by policy to identify the specific needs of identified groups. While the rationale in financial terms is now understood, 70% equating to what a registered provider would pay pounds per square foot for social rented and 40% equivalent to the same for intermediate housing, Mr. Garside explained. The main point is not addressed by this admittedly generous level of subsidy. No amount of subsidy is any use to somebody who can never get a mortgage. In that real sense, the subsidy is not equivalent to policy-compliant affordable housing at all. The appellant's equivalence point is also, of course, a clear attempt to meet the policy requirements of CP5 for social rented and intermediate form of housing, which acknowledges the appellant's acceptance of this policy imperative. Ultimately, given the limitations of DMS in a high-value area such as Surrey Heath, and it not being policy compliant, together with the overall relatively small quantum of units provided as affordable housing, it is reasonable to give only moderate weight to this form of affordable housing for the reasons set out here. The repeated attempts to derive more credit or weight to the affordable housing that is provided by reference to an alternative entirely C2 scheme that could have been provided, that could have not provided any in the absence of there being an adopted policy seeking affordable housing on C2, does not take the appellant's case any further. Apart from the fact it is the decision on the appeal scheme which falls to be determined at this inquiry, not something else. Mr. Garside made clear that the provision of affordable housing on the C3 element was calibrated quite precisely in order to add weight to the appellant's very special circumstances case within the bounds of deliverability. There's nothing wrong with that, and weight is given to the affordable housing provided, but reliance on a hypothetical alternative cannot be used to leverage more weight to what remains the appellant's choice to provide a policy non-compliant form of affordable housing. Nor is the decision not to present a Golden Rules compliant case, instead running a VSC one, capable of deriving any more weight. The appellants have chosen to provide a non-policy compliant form of affordable housing, and for the reasons set out above, the weight this attracts must be limited. Mr. Henderson hints at the proposals almost meeting the Golden Rules with the provision of a further 16 affordable housing units. Proximity to Golden Rules does not add any further weight, and particularly not where, as here, a choice has been made by the developer not to provide any C2 affordable housing, notwithstanding the policies requiring this in the well-advanced emerging local plan. A Golden Rules compliant scheme and a non-Golden Rules compliant scheme are not directly comparable. However, the Golden Rules compliant scheme transcends weight in the sense that it provides a route to approval in a more direct way by determining that the development is not inappropriate. But for the reasons Mr. Henderson outlines, the particular forms of development that allow a scheme to be Golden Rules compliant, this means that no amount of weight to a non-Golden Rules compliant scheme can be said to exceed the notional weight given to a compliant scheme. It appears that the appellants not coming within the Golden Rules actually assist them in that they are able to rely on the site-specific viability study, which finds that any more affordable housing than is offered would render the already unviable scheme undeliverable, according to the evidence of Mr. Garside. In the event of the Golden Rules being met, the appellants would have been denied the reliance on the viability scheme through the effect of the PPG, which prevents developers relying on the Golden Rules from arguing that viability issues prevent them from delivering the requisite affordable housing. And this point of the footnote observes this point seemed to be anticipated by Mr. Garside and appears to explain the distinction made by him between his proof, which is not site-specific, referring only to development typologies, and the FVA itself, which is site-specific. And then I set out the part of the PPG, which for obvious reasons, where development takes place on land situated in or released from the Greenbelt and is subject to the Golden Rules set out in paragraph 156. The framework site-specific viability assessment should not be undertaken for the purpose of reducing development contributions, including affordable housing. Greenbelt surgery. Limited weight to the land for the site of the Greenbelt surgery is also correct, given a distinct lack of certainty about it ever being delivered. The same NHS body, formerly NHS Frimley CCG, although now NHS Frimley ICB, and the same GP surgery, Lightwater, now apparently interested in taking this forward, relatively recently in 2022 failed to develop a site donated by developers in similar circumstances and proposed to be developed as a GP surgery in Windlesham as part of the development of a nearby site in the Greenbelt at Orchard Cottage to be developed as a 66-bed care home. The Orchard Cottage development has now been built out without the GP surgery. The update report to the Planning Committee for Orchard Cottage set out the explanation for this decision at the time from the developers of the site. It is appreciated that Doctor Surgery formed part of the original planning permission relating to this site. It is also appreciated that this proposal followed on a short time after the Doctor's Surgery Central to Windlesham was closed. This decision was made over 10 years ago on the basis that it was believed inefficient and ineffective to retain the surgery at Windlesham. The preference then was to centralise the provision and delivery of the GP services to residents of Windlesham at the Lightwater surgery, only a short distance away, less than 2 miles from the application site, and only a little over a mile from the centre of Windlesham. It is understood, and it remains the case, that there remains insufficient funding available or deemed necessity to make the provision of a doctor's surgery on the site of Orchard Cottage a viable prospect. It is notable here that the NHS Frimley Clinical Commissioning Group have not responded to the current application, despite having been consulted. Frimley ICB, in their initial consultation response to this application in July 2024, were clear that they did not actually want the land at a peppercorn rent, despite a shortage of capacity locally, essentially because they did not have the finance to build new and it cost too much to deliver new premises. The first response is set out there. The first paragraph, the emphasis is originals. In the second and third paragraphs, which I will read from, the emphasis is mine. Second paragraph, we don't support provision of this land as an acceptable developer contribution when provided with land opportunities for entirely new healthcare estates the ICB currently has no access to capital to develop new NHS facilities. New build sites cost significantly more than making amendments to existing premises, and the nature of our restricted estates revenue budget often renders these projects unaffordable. Additionally, where GPs have adopted new build premises, the sizes of these facilities provided under the Health Building Note generates much higher running costs than previous infrastructure, and so partners are often forced to withdraw due to being unable to afford ongoing bills and maintenance fees. So that was July 2024. Their position by the time of the second response, 5 months later in December 2024, remains qualified and lukewarm, referring to the service land which may offer a credible solution subject to patient engagement and financial considerations. It is the same financial considerations, presumably, which had only 5 months earlier led the ICB to conclude that the provision of land was not an acceptable developer contribution because of much higher building and running costs arising from building new facilities. The understandable enthusiasm of the Lightwater surgery outfit does not make the delivery of such a new surgery any more likely. As Lightwater themselves make clear in their letter, they cannot proceed without the consent of the ICB or its successor body, and the ICB letters demonstrate nothing higher than lukewarm or qualified support following a clear rejection of the offer. The most recent email from the ICB, in fact, simply emphasises the concerns about lack of funding or costs articulated already. It does not explain that these concerns have been addressed, still less overcome. By seeking an extension of the period for which the land is available to 8 to 10 years, the ICB are acknowledging the difficulties. In fact, they refer in the email to the complex and long-term nature of NHS infrastructure delivery. They are asking for more time to address the problem, not saying that the problems have been resolved. This email doesn't anywhere describe the offer of free land as anything more than an opportunity, clearly acknowledging the doubts about deliverability as articulated by Ms. Fitzpatrick. There remains a distinct absence of a business plan or any real financial support from either the surgery or the ICB articulated in any of the communications from the ICB, and therefore no certainty that doctor's surgery would ever materialise. The late reference to the inspector's decision at Lingfield makes the council's point well. The inspector in that case gave substantial weight to the medical centre, but that is because he was satisfied that the situation at Orchard Cottage would not be repeated. The medical centre at Lingfield had already been designed into the scheme in collaboration with the ICB's architect, and the owner in that case covenanted, this is from the section 106, not to occupy any C2 integrated retirement community unit unless and until construction of the medical centre has commenced, not to occupy more than 75 C2 IRC units comprised in the development unless and until the medical centre is practically completed to turnkey standard in accordance with the medical centre specification. There are no such provisions in the Section 106 obligation in the present case. The point and the reason why no more than limited weight should be given to the proposed provision of land for the GP surgery, in this case for £1, is that while the prospect of a benefit is already being extended long into the future, with recent experience indicating that the benefit will never in fact be delivered, the harm to the Greenbelt is borne now, regardless. This is exactly what happened at Orchard Cottage. Sang, the proposals are for 8.6 hectares of Sang. This is a considerable increase on the 2.8 hectares that guidance suggests is necessary to mitigate the impact of the population of the proposed development on the SPA. The issue in this matter concerns weight to the excess Sang. The Natural England guidelines, however, articulate the provision of Sang by reference to its quality, not its size. Guidance suggests that adequate car parking at sites over 4 hectares is essential and that there should be a choice of circular routes between 2.3 and 2.5 kilometres in length. These features are described in the guidelines as must-haves. The appeal proposals are for a shortened circular walk of approximately 1.5 kilometres with no car park. Natural England, in their second letter, accept the shortened route in this case and do not object to the proposal. Natural England's reasons were stated and set out in the letter, which I set out there. I won't read that. Natural England have not required a car park in this case, specifically because the SANG is intended for use only by residents of the proposed development and existing residents living within 400 metres of it. The SANG guidance requires certain specified attributes, of which 2 important elements in this case are missing: the circular walk of requisite length and the car park. For this reason, the excess provision cannot attract additional weight as SANG. It appears to be the shape and layout of the appeal site that has dictated the area of SANG to be provided in order just to comply with guidance. Nor is there any requirement or policy support for site-specific bespoke SANG, such as in this case, to provide for existing, beyond 400 metres, or future residents of future housing delivery as claimed. In any event, the east of the borough, where the appeal site lies, is already well provided for with strategic SANG, nor does the possibility that existing residents with 400 metres of the proposed development will benefit from the use of the SANG as a public space, open space, merit more than moderate weight in favour. The appellant's argument that the additional headroom created by the appeal site SANG contribution should not therefore attract more than moderate weight. Conclusion, I'm sorry, that's at the foot of the page there, that's terrible. In policy terms, it is agreed there is a breach of the first part of DM9(2), which expects development to respect and enhance the local natural or historic character of the environment. The remaining elements of DM9 are not applicable to an outline application. Although not cited in the reason for refusal, CP 5 and 6 are both important policies for the determination of this appeal and are breached also, as is Neighbourhood Plan Policy WNP 2.1. Given that the most important policies are out of date in this case and that the determination of the appeal is to be made by applying Framework 153, the overall effect of that is that, taking account of Ms. Fitzpatrick's reweightings to harm and benefits set out in her evidence, the outcome is that the harm to the Greenbelt is not clearly outweighed by other considerations, such that it may be said very special circumstances exist. They do not, and the proper outcome is to refuse permission and dismiss the appeal. Thank you. And then so at the back, I've just attached some policy and the bit from the PPG about golden rules. I don't make any comment on them, they're just there. Thank you.
Thank you, Mr. Atkinson. Thank you for that. Okay, I think then we turn now to the appellant and closing the submissions on behalf of the appellant from Mr. Young. Mr. Young.
Thank you. There are 8 cases of the Supreme Court, Court of Appeal and High Courts that accompany these. We haven't printed them all out for you. We've sent them to your case officer. If you want hard copies, obviously we can provide them. But in each case, it's usually just a few paragraphs of the ratio that's important. These were sent to me and a friend in advance with the paragraph numbers identified as well. Key bits are included in here anyway for you, so you don't have to go hunting for that. Okay, the appellant's closing submissions. At the heart of this appeal is a single issue, does the package of benefits identified by the appellant clearly outweigh the harm by reason of inappropriateness and any other harm, such that very special circumstances exist, warranting the grant of planning permission? The appellant's view is that it does, by a very significant margin. The officer report took the same view despite identifying conflict with the development plan. Just last week, the Secretary of State at Lingfield House took the same view on a very similar Greenbelt IRC proposal, despite a markedly less generous affordable housing offer and open space. The appellant invites USERD in this appeal to take the same view on its particular facts. It's important to appreciate at the outset the approach why. That is the question which sits at the heart of this appeal, and to understand the approach which the appellant has taken. The appellant might have arrived at the appeal seeking to inviolate the parties in a complex argument about the proper approach to the golden rules on a C2 scheme. It might have sought simply to rely on a blanket assertion that as a grey belt site, limited harm to the green belt was a done deal. It has not done any of that. This appellant has arrived at this appeal fully and freely fronting up to the fact that the scheme is not compliant with the golden rules and accepting that it must demonstrate very special circumstances. It has sought to provide detailed and careful evidence as to why it's not viable for the scheme to be golden rules compliant, and to demonstrate through a series of expert witnesses why the package of benefits which it suggests really does justify being badged very special circumstances. It has also sought to provide detailed evidence on the extent and impact on the Greenbelt harm, carefully delineating the different aspects of that harm which arise as a matter of policy, and presenting clear evidence in support of its position on every one of those aspects. At the conclusion of this inquiry, the appellant's case remains as it was at the start, in light of the relatively limited level of harm to the Greenbelt and the truly exceptional package of measures provided by way of very special circumstances. This appeal ought to be allowed, and in closing, we take each of the main issues in turn. Starting then with the extent of the harm to the Greenbelt, it's agreed the proposal is inappropriate development in the Greenbelt. There would be no question that it is appropriate development if one thing were changed. If the scheme provided 50% affordable housing for the 33 homes, that's 16.5, and 15% for the C2, that's 23.1, that is 39.7 rounded to 40 affordable units. The proposal delivers 23 affordable homes. All meet the definition of affordable. Under the definition in the NPPF, it would have also met the definition of intermediate housing when that was defined in the NPPF 2012 as both identified discount market sale as a form of affordable housing. The local plan predated even the first version of the NPPF. It's badly out of date in terms of what amounts to affordable housing. Its requirement for 50% social rented and 50% intermediate must be seen in that light. But even in light of policy CP5, the proposal delivers 100% affordable housing for the non-self-build housing units, 70% for all the C2 housing, including the self-build, 70% discount on 11 homes, equivalent to what a registered provider would pay for social rented units, and 40% discount on 12 homes. It's accepted that even with the 70% discount, it does not deliver social rented homes with all the protections that offers to tenants. And in any event, it is 17 units short of what would be necessary to meet the Golden Rules requirement if it is required for C2. That is arguable given the wording in paragraph 156 refers to major development involving the provision of housing. C2 is not housing, it is residential institutions and covers accommodation with care. That is not housing. The reference to involving housing should not cover parts of a development which are not C2. Sorry, not C3, I should say, not C3. Yeah, that's right, yeah, thank you, yeah. For example, a proposal for 2 houses and 1 care home, also C2, should not require affordable housing for the care home. But be that as it may, the appellant has taken the decision to accept the proposal does not meet the golden rules and hence relies instead on very special circumstances. The reason for this approach is that the scheme is not viable with 40 affordable units. This is the uncontested evidence of Mr. Garside. Pursuant to the guidance in the PPG, one cannot raise viability as a way of avoiding the golden rules. It's inevitable that a decision maker would legitimately ask why a proposal on a grey belt site is failing to meet the golden rules. If the answer is financial viability, then the appellant with a green belt site has to argue its case under very special circumstances, not paragraphs 155 and 156 of the NPPF. That means that such a development proposal is inevitably inappropriate development. The harm to the green belt. There is a fondness for dissecting greenbelt harms into various components. Sometimes it's argued that there are three types of greenbelt harm: definitional harm, harm to openness, harm to the purposes of the greenbelt. The harm to openness is then subdivided into harm to visual openness and harm to spatial openness, and this follows the judgment in Turner in the Secretary of State and East Dorset Council, where the Court of Appeal held at paragraph 16 that the absence of visual intrusion does not in itself mean that there is no impact on the openness of the greenbelt, because the spatial impact on openness must also be considered. So that means there are four types of harm. As with most development, the effect is permanent and there will be new activity in the greenbelt, but that must be seen in light of the fact that it is mostly a retirement village. Decision makers must give substantial weight to any harm in the greenbelt. Provided that is done, there's no legal error. But to arrive at that conclusion, one only need find that there is harm to the greenbelt, which is plainly the case, and then give it substantial weight. That's basically what Mr. Henderson has done. He's accepted that the definitional harm is substantial. In arriving at that harm, he's focused on the so-called definitional harm of simply being inappropriate development in the countryside. That being so, there seems little point in looking for additional forms of harm in the greenbelt. There's a real risk here of double counting the harms, especially if you give the definitional harm is treated as substantial harm. In truth, Mr. Henderson has been very efficient. One should look at both harm and weight. By going straight to substantial harm, he's cut to the chase. Plainly, that should be given significant weight. Mr. Henderson does examine harm to openness as an additional issue. He finds and gives this additional greenbelt harm limited weight. In spatial terms, over half the site is undeveloped. And in visual terms, the harm is significantly constrained by the very enclosed nature of the site, surrounded as it is by built development on four sides, a major road on the fifth side, and very strong vegetation around almost the entire perimeter of the site. The council give the spatial harm moderate weight and significant weight to the visual harm. That should read, the latter is in particular seems unconvincing. Harm to spatial openness. Ms. Fitzpatrick does not seek to suggest that the harm to the spatial openness of the greenbelt is anything higher than moderate in this case. Mr. Hammond's view is that even that is overstated and that the true level of spatial harm is more limited. Either way, it's clear that harm to the spatial openness of the greenbelt is not the focus of this appeal. That, again, is not a neutral point. The fact that there is no more than moderate harm to the spatial openness of the greenbelt is yet another factor which goes to reducing the level of harm overall. That lack of harm of spatial openness derives predominantly from three factors. Firstly, there will be no impact at all upon the spatial openness of the majority of the site, as it will remain as undeveloped SANG and public open space. 8.6 hectares of SANG is to be provided, sweeping round from the southern border of the site across its eastern edge and up to the northeastern corner by Windlesham Court. The point was put crisply by Mr. Atkinson in cross-examination of Mr. Hammond when he said, and I quote, "There is a large area of SANG, which means that in spatial terms there is no impact across broadly half of the site." Secondly, as Mr. Fitzpatrick also accepted in cross-examination, there is built development to various extents on 4 of the 5 sides of the appeal site, with the 5th side being the A30 itself. The appellant entirely accepts that the extent of that built development varies, but it is there on almost all sides. To the west, there is extensive residential development comprising the village of Windlesham. To the south, there are large-scale residential dwellings with commercial development and a series of light industrial units beyond. To the southwest and west are further scattered larger residential dwellings. To the east, there is yet further large-scale dwellings along Windlesham Court, including a row of 3-storey terraced houses close to the eastern boundary of the site. To the north, as indicated, is an A road. As such, in spatial terms, the site is enclosed by development on all sides. That inevitably reduces the extent of harm to the openness of the greenbelt caused by development on the appeal site, indeed substantially so. Third, and importantly, in spatial terms, the site is indisputably edge of settlement in nature. It shares one long western boundary with the built-up edge of Windlesham village. The parties differ as to what the result of that might be in visual terms, but in spatial terms its effect is clear: to reduce the extent of spatial openness of the site and therefore to reduce the harm of spatial openness caused by the appeal scheme. For those reasons, Mr. Hammond is correct to contend that the harm to spatial openness is limited. Ms. Fitzpatrick does not put it higher than asserting moderate harm in any event. The real battleground is as to the extent of harm to visual openness. Visual openness. Ms. Fitzpatrick's evidence is that significant harm to visual openness of the greenbelt arises. Mr. Hammond's evidence is that only limited, very localised harm to visual openness arises. On the totality of the evidence, that dispute can only realistically be resolved in the appellant's favour. At the forefront of that evidence is the assessment of Mr. Hammond. Mr. Hammond is a qualified landscape architect with 20 years' experience in conducting landscape and visual assessments. He's produced for USA the benefit of an extremely detailed landscape and visual impact assessment and proof of evidence. Those documents include a carefully produced zone of theoretical visibility, which models the visibility of the scheme based on its proposed massing and density compared with topography, building and tree cover, and other features affecting visibility. He has also produced a large number of photo wires and viewpoints, modelling the visibility of the scheme from various locations, following agreement with the council on the locations of those viewpoints. He draws upon all of that to reach his view that the harm to visual openness is limited and very localised. Ms. Fitzpatrick's contrary assessment is, in simple terms, out of kilter with the council's own evidence base, the assessment provided within the officer's report, and the assessment of Mr. Hammond. Taking those assessments in the round, the combined weight in favour of a lower level of harm to visual openness than for that for which Ms. Fitzpatrick contends tells decisively against her position. That is particularly clear in respect of the council's own landscape sensitivity assessment. It is of immediate relevance that the LSA described the northern edge of Windlesham, within which the appeal site sits, as significantly wooded. The substantial tree cover across, in particular, the northern boundary of the site is critical to the visual enclosure for which Mr. Hammond contends. The LSA then goes on to describe landscape character area SS6 in terms which match the appeal site perfectly. Limited public access is identified as giving rise to low sensitivity. The appeal site is inaccessible to the public, and the majority of the receptors are highly transient in cars along Snow's Ride, which has no public footpath, or in higher speed cars along the A30. As regards perceptual aspects, the LSA goes on to identify that the influence of the A30, piecemeal development along its course, and the settlement of Snow's Ride limit the sense of remoteness and tranquility. That again is a neat encapsulation of the nature of the appeal site. As regards visual prominence, the LSA describes the landscape of SS6 as visually enclosed by woodland and boundary vegetation, which substantially limits views. That is, once again, entirely on the money as regards the appeal site. The The LSA then goes on to analyse SS6A, including the appeal site as a sub-area, and correctly identifies it as having a moderate sensitivity to development. It does so for reasons which again exemplify why the above assessment of SS6 applies so cleanly to the appeal site. Precisely the same limitations on visual openness are identified. Existing built development and associated road infrastructure, very limited public access, strong boundary edges, an enclosed character with limited views into and out of the area, and the overbearing presence of the A30. On top of that, the appeal scheme illustratively complies with every one of the specifically identified suggestions for mitigation: retain tree cover, avoid an urbanising effect on London Road, and concentrating development adjacent to Snow's Ride. Ms Fitzpatrick's final salvo was to place considerable weight on the visibility that she asserted would be created by the access and by the gap in the trees towards the southern end of Snow's Ride. It is here that Mr Hammond's viewpoints come into their own. They clearly demonstrate that the proposed development of the Sang and landscape buffer means that the majority of those views will remain open, with the built development appearing only in oblique form in the background. The short point, therefore, is that Ms Fitzpatrick's assessment of significant harm to visual openness is inconsistent with the officer's report, inconsistent with the Council's own published evidence base, and inconsistent with the evidence of Mr Hammond, the only professional landscape and visual witness to give evidence to the inquiry. In those circumstances, her assessment simply cannot hold water. In short, therefore, as regards openness, spatially, the Council does not contend that the level of harm would be any greater than moderate, but it is in any event clear that on a site bounded on all sides by built development and an A road, where over half of the current openness of the site will be retained via the Sang, the effect on spatial openness is no greater than limited. And visually, Ms Fitzpatrick's assessment of significant harm is greatly overstated. This is a highly visually enclosed site, which is not publicly accessible, in respect of which intervisibility from both main receptors, Snow's Ride and the A30, is already heavily limited by existing tree belts and will only be reduced further by the proposed landscape buffers. All of those factors are reflected in the officer report, the Council's own LSA, and the evidence of Mr Hammond, all of which Ms Fitzpatrick departs from without clear reason. Harm to the purposes of including land in the Greenbelt. It's agreed there is only harm to one of the 5 purposes of including land in the Greenbelt. This is encroachment purpose C in the MPPF paragraph 143. The Council do not allege harm to to check the unrestricted sprawl of large built-up areas. The fact that the Council do not allege harm from unrestricted sprawl is important because the Supreme Court has held that openness is the counterpart to urban sprawl, and that's in the Samuel Smith Old Brewery Tadcaster case. That rather supports Mr Henderson in his finding that the harm to spatial openness is limited. Harm to purpose C. Much of the above is of direct relevance to the issue of the harm to purpose C. The question is the extent to which the site assists in safeguarding the countryside from encroachment, and the extent to which the scheme would harm that purpose. 2 aspects of common ground identified above are critical in that assessment. First, it's common ground that the site is already bounded on 4 of 5 sides by residential and commercial development of various different forms. As the Council's own evidence base accepts, even scattered developments of the kind that bounds the east and north of the site can properly be described as urban in nature. That must be combined with the A road to the north and the existing conurbation of Windlesham to the west. That common ground, accepting in effect that the site is ringed by urban influences, is an unpromising starting point from which the Council seek to assert that the site plays a strong role in safeguarding the countryside from encroachment. Secondly, it's common ground that spatial harm to openness as a result of the scheme is no greater than moderate. That is of real relevance when considering whether it can be right for Ms Fitzpatrick to assert, as she does, significant harm to Purpose C arises. It's difficult to see how Mr Fitzpatrick can consistently assert that harm to spatial openness is limited by the boundary development which encloses the site, but also that there would be significant harm in the form of encroachment and development on the site into the countryside. Any risk of encroachment must be materially lower where the site is already bounded by urbanising development on all sides. Against that background, for the reasons explained by Mr Hammond, the reality is that the harm to Purpose C is again limited. At risk of overanalysing the wording of national policy, the simple point is that the site is neither countryside itself, nor is it playing any significant role in preventing encroachment. As to whether it is countryside, the site is surrounded by built form in varying different degrees, much of which is concentrated to the west along Snow's Ride and large scale, having regard to the size of the properties to the north and east of the site. Combined with the very present impacts of the A30 to the north, the reality is that whatever countryside feel the appeal site might have possessed at one point in time, it is now compromised substantially by the urban forms surrounding it. As to the extent to which it is preventing encroachment, as Mr Hammond also points out, the countryside, such as it is between Snow's Ride and its nearest neighbour, Windlesham proper and Sunningdale, is already pocketed by sporadic development of a residential and commercial nature. The distances are also significant. Along the A30, it is 1.8 kilometres between the appeal site and Sunningdale. The suggestion, therefore, that development on the site will result in a notable encroachment into the open countryside said to exist to the east is unrealistic. In response, much was made by the council of the various different ways in which the appellant's witnesses have sought to describe that combination of factors, including peri-urban and inherent countryside. Those criticisms did not seem to amount to a contrary case, rather criticism for the sake of it. The appellant entirely accepts that all such terms are open to debate in terms of their utility. It is never straightforward to seek to capture the character of a site in a short, compact phrase. But the meaning which each of these phrases was seeking to convey has been clear and consistent. The appeal site is itself open in the sense it possesses the defining characteristics of the countryside, but by reason of its adjacency to the settlement edge and other urbanising features, such as the A30, does not possess anything like the kind of open, expansive, rural quality one would associate with the open countryside in most parts of the country. Those criticisms of Mr Hammond and Mr Henderson do not, therefore, advance matters materially. On the substance of Purpose C, the Purpose C issue, the Council hangs its hat on its own 2022 Greenbelt Review, which identified the contribution made by Purpose C as strong. As Mr Hammond explained, that 2022 review comprised an upgrade from the previous 2017 assessment, which graded its performance against Purpose C as moderate. The critical question, therefore, is whether the Council can demonstrate any coherent basis for the upgrade between 2017 and 2022. If it cannot, it follows that the conclusion of the 2017 review stands and the central plank of the Council's case on Purpose C falls away. As explained by Mr Hammond, the 2022 review does not withstand scrutiny on this point. The central distinction between the two documents is the conscious redrawing of the boundary of the study area, resulting in the 2022 review adopting an arbitrary study area comprising some, but not all, of the residential development which impacts it, and then, perhaps unsurprisingly, drawing the conclusion that urbanising effects are overstated in the earlier version. In short, the only basis identified by the 2022 review for taking a different view is circular. Residential development has been removed from the study area, resulting in reducing urbanising influence. Redrawing those boundaries might be justified if they produced a more tenable study area, but they do not. The study area in the 2022 review excludes all residential development save 2 dwellings to the south-east of the site. For no reason at all, it excludes the collections of dwellings further south and further east. which were included in the 2017 study and which evidently have an urbanising influence. No justification is provided for that. It is entirely arbitrary. As such, there is simply no clear or rational justification for the upgrading within the 2002 review of the contribution made by the appeal site to Purpose C. If that premise falls, so does the council's case on Purpose C, which, as was put to Mr Hammond in cross-examination, relies almost entirely on that document. Last but not least, a point was taken with Mr Henderson in cross-examination about the level of activity on the site caused by the scheme, which was said to result in quite a lot of activity, quite a lot more activity than is presently the case, contributing to substantial harm to Purpose C. That again is grossly overstated, particularly in the context of a scheme which is to be occupied primarily by people over the age of 79, with sufficient extra care needs to justify moving into IRC in the first place, other than at a very localised site-specific level. Any increase in activity will not be of any great moment. That point, as such, adds nothing. Conclusion on definitional harm, openness and the purposes. Overall, this is a case where most of the harm to the Greenbelt is the definitional harm. The harm to openness and the purposes add little to the equation. It is, however, necessary to identify the harm to openness, spatial and visual, and harm to the purposes, but they add little weight to the substantial weight Mr Henderson has fairly given to the harm by reason of inappropriateness. The relevance of it being grey belt, there is now the additional factor of sites which are grey belt. It's agreed that informs the position on the extent of the harm. The harm must be less for the proposal on grey belt land, than a site which is not on grey belt. It's important here in a decision-making process to focus on the development rather than the land, and that's the recent judgment of Mrs Justice Leven in the Rotherham Parish Council case. I won't read that out. It arrives at that conclusion in the context of the decision you're making. Paragraph 46, this is agreed to be a proposal on grey belt land. Bringing all of this together, it must follow that where there is reduced harm to spatial openness, the appellant says limited, and reduced harm to visual openness, the appellant says limited, and it is agreed that there is harm to only one of the 5 purposes of the green belt, and it's agreed to be grey belt, then the harm to green belt cannot be the full harm that would arise if none of those mitigating factors didn't apply. Benefits to the Greenbelt, added to which there is a benefit in Greenbelt terms because the proposal will provide public access to a large area of over 8 hectares of land in an area where there is very little publicly accessible land. This will allow for new recreational use in Greenbelt land as advocated in the NPPF paragraph 151. It's important to note the existing very extensive and attractive vegetation means the Sang here will become a desirable location for, recreation. It is attractive for development, self-evidently, but recreation in that paragraph. The Sang is located as far away from the road as it's possible to be. The buildings on the site will further help to mitigate, to help reduce the impact of noise from the A road. Moreover, this is no ordinary open space. It will be landscaped to create a suitable Sang, and it will be maintained on an ongoing basis at a cost to the appellant of £1 million. That is something that goes into the assessment of Greenbelt harm. There is then the additional benefit of enhancing the biodiversity of the area as the proposal would deliver 10% BNG. This too is a benefit in the Greenbelt as per NPPF paragraph 151. What the NPPF is seeking to do is ensure decision makers are not persuaded by giving Greenbelt harm limited or moderate weight overall. There is Greenbelt harm here. Mr Henderson believes it should be judged as substantial harm. It's difficult to fault his conclusion. He has hardly underplayed the harm in this case. Next, excessive legalism. There is a risk of excessive legalism here. Lord Justice Lindblom in the Court of Appeal made this clear in East Staffordshire Borough Council. At paragraph 50, he stated the following: "I would, however, stress the need for the court to adopt, if it can, a simple approach in cases such as this. Excessive legalism has no place in the planning system or in proceedings before the planning court or in subsequent appeals to this court. The court should always resist overcomplication of concepts that are basically simple. Planning decision-making is far from being a mechanical or quasi-mathematical activity. It is essentially a flexible process, not rigid or formulaic. It involves largely an exercise of planning judgment in which the decision-maker must understand relevant national and local policy correctly and apply it lawfully to the particular facts and circumstances of the case in hand, in accordance with the requirements of the statutory scheme. The duties imposed by Section 72 of the subsection 2 of the 1990 Act and Section 38(6) of the 2004 Act leave with the decision maker a wide discretion. The making of a planning decision is therefore quite different from the adjudication by a court on an issue of law." In the context of the Greenbelt, the point was further articulated by His Honour Judge Eyre QC in Sefton Metropolitan Borough Council and the Secretary of State. He held that decision makers in Greenbelt cases should not adopt a mathematical approach to this matter. The reference to great weight to be given to any harm to the Greenbelt is to be seen as a metaphor. The claimant's argument is also flawed, this is obviously the judgment, by taking metaphorical language unduly literally. The reference to substantial weight being given to harm is ultimately a metaphor, as is the reference to the harm being clearly outweighed by other considerations. The exercise to be undertaken is not one of balancing weights on scales, nor even one of saying that harm to the Greenbelt is equivalent to a particular weight, say 10 stone, while a different circumstance, such as an applicant's family circumstances, can never be rated as equivalent to more than a different weight, say 5 stone. Rather, the language of weight and weighting is being used to emphasise the importance of the Greenbelt. It is used to make it clear to decision makers that they cannot approve inappropriate development in the Greenbelt unless the considerations in favour of the development are such as truly constitute very special circumstances, such that the development can be permitted notwithstanding the importance given to the Greenbelt. The realisation that the reference to weight is ultimately a metaphor highlights a practical difficulty in the approach for which Mr. Riley-Smith presses. How is the decision maker to decide what is equivalent to substantial plus substantial? The claimant envisages the balancing exercise being quasi-mathematical, but if that is the appropriate exercise, then paragraph 144 fails to provide the decision maker with guidance as to the values to be placed in the necessary mathematical calculations. When paragraphs 143 and 144 are read together, they can be seen as explaining that very special circumstances are needed before appropriate development in the Greenbelt can be permitted. In setting out that explanation, they emphasise the seriousness of harm to the Greenbelt in order to ensure that the decision maker understands and has in mind the nature of the very special circumstances required. They require the decision maker to have real regard to the importance of the Greenbelt and the seriousness of any harm to it. They do not, however, require a particular mathematical exercise, nor do they require substantial weight to be allocated to each element of harm as a mathematical exercise, with each tranche of substantial weight then to be added in the balance. The exercise of planning judgment is not to be artificially sequenced, to be an artificially sequenced two-stage process, but a single exercise of judgment to assess whether there are very special circumstances which justify the grant of permission, notwithstanding the particular importance of the Greenbelt. That was the approach that was taken to the relevant parts of PPG2 and to the previous iterations of the MPPF. In light of this and the other case law, you, sir, your task in respect of Greenbelt harm is simply to do the following: acknowledge the degree of harm arising from inappropriateness and weigh it. Acknowledge and weigh harm to openness, both spatial and visual. Acknowledge and weigh the harm to the Greenbelt purposes, acknowledge the fact the development proposal means the land is Greybelt, acknowledge that the provision of recreational benefits of the Greenbelt, acknowledge and weigh the enhancement of biodiversity in the Greenbelt, give an overall level of harm to Greenbelt, not subdivided, and give that harm substantial weight. None of the above should be treated as benefits. The reduced level of harm arises from factors 2 to 5 above should be treated as such and not counted as positive considerations supporting the proposal, and that's the Lee Valley Regional Park case at paragraph 47. The court held that the absence of a severe harm cannot reduce the harm by reason of inappropriateness or the harm actually done to the openness of the Greenbelt. A very similar approach to one Mr. Henderson adopts was addressed by Mr. Justice Sullivan, as he then was, in Doncaster Metropolitan Borough Council and the Secretary of State, in terms of focusing on the definitional harm, with harm to openness and purpose adding little additional harm. And I quote, "Thus applying the policy set out in paragraph 3.2 of PPG 2, the proper question for the inspector in the present case was whether the harm by reason of inappropriateness and the further, albeit limited harm, caused to the openness and purpose of the Greenbelt were clearly outweighed by other considerations. Those other considerations were confined to the benefit to the appellant's family, and particularly the children, of allowing the appeals. But it was only if those benefits not merely outweighed the limited harm caused to the openness and purpose of the Greenbelt, but if they clearly outweighed the harm by reason of inappropriateness and the further, albeit limited harm, caused to the openness of the purposes of the Greenbelt, the very special circumstances could be found in terms of paragraph 3.2 of the PPG 2. It's very important that full weight is given to the proposition that inappropriate development is by definition harmful to the Greenbelt. That policy is a reflection of the fact that there may be many applications in the Greenbelt where the proposal would be relatively inconspicuous or have a limited effect on the openness of the Greenbelt. But if such arguments were to be repeated, the cumulative effect on the many permissions would destroy the very qualities which underlie Greenbelt designations. Hence the importance of recognising at all times that inappropriate development is by definition harmful, and then going on to consider whether there will be additional harm by reason of such matters as loss of openness and impact on the function of the Greenbelt. Given that inappropriate development is by definition harmful, the proper approach was whether the harm by reason of inappropriateness and the further harm, albeit limited, caused to the openness and purpose of the Greenbelt was clearly outweighed by the benefits to the appellant's family and particularly to the children as to the amount of very special circumstances justifying an exception to Greenbelt policy. The difference here is that there are some Greenbelt benefits, recreation and biodiversity, also lessening the Greenbelt harm, and then a host of other benefits which are far more extensive and see below. And relatively uniquely, which has historically been important in terms of avoiding the risks of creating a precedent. That was a particular concern under the previous government, where ministers expressed in written ministerial statements the view that unmet housing need would not normally amount to very special circumstances on their own. It's important to note, however, that the government policy has clearly moved away from such a concern about precedent since Labour came to power. So in a conservative era, inspectors allowing appeals for IRC and extra care highlighted the fact the proposal also delivers healthcare benefits for elderly people, as well as meeting unmet need for specialist accommodation for the elderly, addressing the shortfall in the five-year-land supply and freeing up family housing. My point there just briefly is they found additional factors that got over the written ministerial statement, I think it was Brandon Lewis, by just going beyond pure housing benefit, and that was the health and care benefits of IRC. Other harm. Before turning to the benefits in the case, there is a need, under the test in paragraph 153, to consider other harms. The harm to character and appearance of the area is a separate issue to Greenbelt harm. The lack of harm to visual openness and spatial openness are not covered by this issue, albeit there is overlap. A separate conclusion on this should be reached. And see below main issue 2. Mr. Henderson finds there is a breach of DM9, as did the officers, but Mr. Henderson finds that is limited harm. The inspector could, of course, find no harm. That is perfectly possible. But Mr. Henderson's concession on the breach is solely related to harming the undeveloped nature of the site. This is only part of one of the many criteria in DM9. There is the permanent loss of some agricultural land, which is always a harm, but again, that is given limited weight by Mr. Henderson. There's no development plan policy for this. Compliance with the development plan. It's a very unusual case in that there is no alleged conflict with Greenbelt policy in the development plan. The highest it gets is the single sentence in CP1 suggesting development in the countryside will be opposed as the Greenbelt boundary will be maintained. This is a case which benefits from particularly close regard being paid to the exercise which all decision makers are required to undertake, namely that set out in 38(6) of the Planning and Compulsory Purchase Act 2004. As Mr. Fitzpatrick agreed, the reason for refusal contains an allegation of conflict with just two policies within the adopted plan, DM9 of the core strategy and WNP21 of the Windlesham Neighbourhood Plan. Ms Fitzpatrick went on in her evidence to allege conflict with CP1 of the core strategy, but accepted in cross-examination that did not appear in the reasons for refusal and that she had no authority from members to pursue that argument. It does refer to maintaining Greenbelt boundaries, but based on the very out-of-date housing requirements and no requirement for C2 uses like extra care or IRC. As explained by Mr Henderson, any conflict which you, sir, identify must be afforded very limited weight, as CP1 delineates settlement boundaries predicated on a housing need figure utterly disconnected from reality. And please see the Supreme Court in Suffolk Coastal Hopkins and Richborough and Cheshire West, sorry, that should be Cheshire East. In the Supreme Court, paragraph 77, 70, 93, just to add that that's where the court talks about, if there's no 5-year land supply, then you should be applying these policies that stand in your way flexibly. Can I also just ask you to add reference to Lord Carnworth at paragraph 64? Mr Henderson will just check that, paragraph 64, where he deals specifically with the Richborough case, out-of-date housing numbers, reduce the weight to give to the offending policy. Main issue 2, extent of harm to character and appearance. Context is important on the issue of character and appearance. This is a site which is not covered by any landscape designation nor any environmental designations, is not a valued landscape, is not in proximity to a conservation area, and critically, is not publicly accessible. It is in a part of the borough which the council's own evidence base accepts has the potential to accommodate change, so long as development is perceived as being part of the Snows Ride development to the site's western boundary, which is precisely what the scheme proposes. Mr Hammond's view that the scheme gives rise only to limited harm to character and appearance is again to be preferred against that background. The nub of his evidence can be summarised in 4 short points. First, whether peri-urban is a useful description or not, it is indisputable that the site is surrounded by clearly perceptible urban influences. The fully built-out settlement edge of Windlesham to the west, a busy A road to the north, the scattered residential and commercial developments to the south and east, including a clearly perceptible 3-storey terrace development to the immediate east. That alone substantially reduces the effect of development on the site in character and appearance terms. Secondly, as already established, the visual impact of the scheme will be highly localised as a result of the extensive boundary vegetation, the lack of public access, and the transient nature of the receptors along the A30 and Snows Ride. Third, the scheme proposes to reduce the impact on character and appearance further through the retention of the existing boundary vegetation overall, save for access, the inclusion of significant boundary planting, and by the careful siting of development at the edges of the site closest to existing built development. Importantly, even if those built form zones do, as was suggested to Mr Hammond in cross-examination, result in an intensification of the visual effect on the western edge of the site. The application is in outline form only, and the precise nature of the massing and location are yet to be fixed. The officer's report is clearly in raising no objections to the architectural quality of the anticipated development and the Council advances no contrary case now. Fourth, as discussed above, the site will benefit from extensive areas of sang, public open space, and retained and additional landscaping. All of those will serve to contribute to retaining the existing open character of more than half the site, as Mr. Hammond has again explained, as Ms. Fitzgerald has not sought to doubt. The starting point for the Council's contrary case, as put in cross-examination to Mr. Hammond, was that his assessment of harm and that of Ms. Fitzgerald's were not, in fact, all that far apart. It's not immediately clear where that argument leads. Mr. Hammond's evidence is that the appeal gives rise to only limited harm to character and appearance. If the Council's case is not substantially different from that position, then the appellant gratefully accepts that analysis and struggles to see what is left for you to determine. It is not, in any event, a good point. On the maths, it may be correct to say that both Ms. Fitzgerald and Mr. Hammond treat the majority of the harms arising as being level 2 of 4, but that is only of any relevance if one ignores the words that both witnesses apply to the second level. Ms. Fitzgerald's second level of harm is significant, Mr. Hammond's is moderate. They are clearly not the same, therefore, once one moves past the basic maths. Aside from those already dealt with, the two new points taken by Ms. Fitzgerald under this topic are that the site has a transitional quality, and B, that it is relatively tranquil, makes a significant contribution to the character and appearance. Point A is overstated. There is a difference in character to the east and west of Snow's Ride, but it is perceptibility and impact upon the overall character of the area is far more limited than Ms. Fitzgerald's assessment suggests, particularly when one cannot actually move across the site as it is not publicly accessible. Point B is also overstated, entirely unsurprising for a site which shares a long northern border with a major A road. It is not tranquil. In cross-examination of Mr. Hammond, the Council appeared to suggest that there was some kind of tension between this suggestion and visual harm was limited to the thick tree belts on the A30, and that character harm was limited to the clear presence of the A30 felt on site. There is no tension at all. As Mr. Hammond explains, character is about perception, not just visuals. So it is entirely consistent and entirely true to assert both that the visual harm is limited by the enclosed nature of the site and that the character of the site is nonetheless not tranquil because of the very real and audible presence of the A30. There is, in short, no merit in the Council's character and appearance objection. Turning to the policies said to be breached, central focus was placed on DM9. This is peculiar because DM9 is obviously and on its face concerned with design. This is an outline application. That gives rise to the following analysis. There's no conflict at all with 8 of the 9 requirements of DM9, marked by Roman numerals 1, 3 through to 9. No such conflict was alleged by Ms. Fitzgerald, and none could possibly arise given the subject matter. Within DM9, Roman 2, no possible objection could be mounted to the scheme on the basis of its approach to scale, materials, massing, bulk and density, on the basis that all those issues are preeminently for reserved matters. What remains within DM2 is the necessity to, and I quote, respect and enhance the local nature or historic character of the environment upon which Ms. Fitzgerald puts her case. But the policy must be read as a whole. The clause is caveated in 2 ways. Firstly, by the opening words of DM9, development will be acceptable where it achieves the following design principles. The reference in DM9.2 to character cannot, therefore, be read as general character and appearance policy, but as a design principle. It cannot, on an outline application, have more than very limited relevance. As a result, the second caveat is the requirement to pay particular regard to the 5 matters already identified, which are preeminently for reserved matters. Again, therefore, it's clear that DM9 is not a generalised character and appearance policy, but one focusing very specifically on matters which are only peripherally relevant on an outline application. That limits substantially the degree of conflict which was properly accepted by Mr. Henderson to exist. As regards WNP 2.1, Mr Henderson's approach is clearly correct. There is no conflict at this outlined stage. The identified conflict with DM2 must then be weighed against the remainder of the development plan. There's no other conflict alleged with any other policy across either the core strategy or the neighbourhood plan in the reason for refusal. Clearly, breaches of an emerging local plan cannot contribute to that question, particularly whereas here it's established that the plan is to be afforded limited weight. That being so, as Mr Henderson identified, the position in relation to the first question under 38.6 is clear. Even on the council's case, taken at its highest, there is conflict only with one aspect of one sub-paragraph of one policy of the core strategy, for which one has to ignore the obvious design-focused context. Even if the council is correct on that issue, there is clearly compliance with the development plan as a whole when one takes into account the fact that the scheme accords with every single other policy in the adopted plan. Even if all the above were wrong, however, it's common ground between the parties, as accepted by Ms Fitzgerald, that the local plan is painfully out of date. That was a sensible concession for all kinds of reasons. First and most obviously, the council is unable to demonstrate a 5-year housing land supply by some considerable margin. Second, the plan is, on its face, almost 15 years old, having been adopted in the early part of 2012. Thirdly, as a result, the plan predates even the very first iteration of the NPPF. Remarkably, therefore, Surrey Heath is an authority that has never had a local plan examined against any of the policies within the NPPF. That datedness shines through from the plan. Fourth, the plan is, as a result, seeking to meet a local housing need taken from an old regional spatial strategy, which quite simply has nothing whatsoever to do with the extent of local housing need in the borough now. Furthermore, as Mr Fitzpatrick all but accepted in cross-examination, the emerging local plan is a world away from an acceptable solution to any of those problems. Most starkly, it proceeds on the basis of a housing need figure, which is approximately a third of the actual need calculated according to the standard method. It is therefore, as a result of transitional arrangements, proceeding into a fantasy land whereby it will allocate land, adjust greenbelt boundaries and seek to respond to housing need in a manner utterly disconnected from reality. Even in that world, as Mr Pycroft identified, it's still unlikely to have a 5-year housing land supply. A 5-year land supply will exist on adoption. Of course, Ms Fitzpatrick is correct to state that simply because a development plan policy is out of date, it does not follow that it attracts no weight. But it is obvious, in light of the sheer number of different bases upon which the particular development plan is out of date, and the absence of any clear solution in even the relatively near future, that those policies are deserving of no more than very limited weight. In cross-examination, despite not having dealt with the topic at all in her proof of evidence, Ms Fitzpatrick accepted that she had approached the appeal on the basis that she should not reduce the weight to be afforded to an out-of-date development plan policy because the framework directed her to give substantial weight to the harm to the Greenbelt. That is a confused analysis. The question of the weight to be afforded to an out-of-date development plan policy has absolutely nothing to do with the level of weight which the framework dictates should be afforded to some other policy harm outside of the plan. For all those reasons, therefore, the position in relation to stage 1 of the question under section 38.6 of the 2004 Act is clear. There is no conflict with the development plan read as a whole. On any sensible analysis, that arises even if one takes the council's case at its highest, given the almost total irrelevance of DM9, and C, even if, contrary to that, there is conflict with the development plan, the weight to be afforded to that conflict must be drastically reduced to reflect the agreed position that it is painfully out of date for a variety of reasons. Main issue 3, benefits. As already noted, I don't know, we didn't have a break, do we? Do you want a break? Because we're only about, we're not even halfway through yet.
I think that probably would be a good idea. Should we take a break for 20 minutes if this is an appropriate time to do so? Okay, thank you. We'll adjourn until 25 to 12. Okay, good morning again. 11:35 and the inquiry is is resumed even. Before we return to closings from the appellant, I've just been provided with an updated schedule of the conditions. This is version 7, which includes the revised wording for the a speed limit change on Snow's Ride. So I've got a copy of that. Do I take it the councillor's got a copy as well? Will you put a copy up onto the document list, please? Thank you. Mr. Young, back to you.
Paragraph 63 is Lord Carnworth dealing with the Richborough site, and I was referring to that at paragraph 64. So you've got 77, 79, 83, and I just add paragraph 63. 3, yeah, sorry if I said anything else, yeah, 63. Okay, thank you very much. So back to the closing. We're on page 18 and paragraph 82, and we're just about to deal with the benefits. For those who felt depressed at the prospect of me saying we're not halfway, we are halfway. It's 32. I won't be reading out the annex, the appendix, so we're more than halfway through. 82. As already noted, the appellant does not shy away from the fact that the scheme is not Golden Rules compliant and it must demonstrate very special circumstances in order for planning permission to be granted. For the reasons identified by Mr. Henderson in his evidence, it's far from an exaggeration to describe the particular package of measures offered by the appellant, in this case, as unique in the context of extra care schemes. The majority of those asserted benefits have not been subject to any challenge by the council at all. Specialist housing for older persons. There is a crisis in specialist older persons housing at both a local and national level. That description is not melodramatic hyperbole on the appellant's part, but national policy. The PPG specifically identifies the need to provide older persons housing countrywide as critical. Language which it is accepted is not used anywhere else in government planning policy. At a local level, the position of crisis has undoubtedly been reached within Surrey Hills, as Mr. Donner has explained in unchallenged evidence. That is as a result of a combination of 4 factors in particular. Firstly, Surrey Heath has a markedly ageing population. As noted in opening, the percentage of Surrey Heath residents aged 60 and over has increased by 55% in the last 20 years, well above the national average of 40% over the same period, and is projected to have grown by a staggering 73% by 2038. It is no surprise in that context that the emerging local plan describes the demographic of the borough as characterised by an ageing population. Second, the current non-specialist housing stock in the borough is ill-suited to accommodating older persons and poorly adapted to their increased accessibility needs. Over half of the properties within Surrey Heath predate 1975, with that percentage rising to 80% for bungalows. To put that same point backwards, just 20% of bungalows, the favoured type of home for older persons with accessibility needs, were built within the last half century. Third, the level of housing with care stock within Surrey Heath is shockingly low. The current stock available to owner-occupiers comprises just 95 units. That really is astonishingly low. There are no policies within the adopted development plan relating to the delivery of older persons housing, and there is therefore no way of improving the position other than through windfall sites such as the appeal scheme. And fourth, even on Mr. Donner's most conservative calculation, that leaves a shortfall of some 383 housing with care units for sale here, and now rising to 435 such units by 2038. Adopting a more aspirational requirement as recommended by an independently appointed government task force creates a shortfall of between 700 and 1,000 units, increasing to 800 to 1,200 units by 2038. Although the size and scale of that shortfall may give rise to understandable pessimism, the opportunity afforded by this appeal scheme, being as it is a major IRC scheme being promoted by an experienced operator, represents a real opportunity to improve that picture significantly. On its own, the 154 units proposed will more than double current capacity within Surrey Heath and reduced by almost half the existing shortfall. It is no surprise, against that stark background, that the parties agreed that the supply of specialist housing should be afforded significant weight. Lack of a planning pipeline to address the need for IRC. A related issue, to which Mr Henderson properly affords significant weight, is the absence of any pipeline to address the need for IRC units. Ms Fitzgerald attributes this moderate weight, but failed to express any reasoning within her proof of evidence for that view. In examination in chief, her evidence was based on the fact that CP5 addresses specifically older persons' accommodation. With respect, that is nonsense. CP5 makes absolutely no provision for older persons' accommodation whatsoever. It simply identifies that older persons' accommodation exists as a discrete category. That does nothing at all to address the lack of pipeline to address IRC need. Significant weight is plainly appropriate. Affordable housing, one will be forgiven for thinking, from the Council's approach to the issue throughout the inquiry, that the appellant's offer of a mix of 40 and 50% discounted market sales housing was not really an offer of affordable housing at all. As a matter of policy, it unquestionably is, as the NPPF makes clear, with the established 3 further points of context are vital in assessing the proper weight to be afforded to the affordable housing offer made as part of the scheme. Firstly, it's common ground that the offer substantially exceeds in numerical terms the requirement within the development plan policy. Compliance with the development plan would require the delivery of just 13 affordable units, representing 40% of the C2 on site. The appellant is therefore providing 10 more affordable units than is required of them under the development plan, and insofar as pure non-specialist C3 housing is concerned, proposes a 100% affordable scheme. Secondly, the extent of the discount being offered as part of the discounted market sale product is truly exceptional. Mr Garside and Ms Fitzgerald both gave evidence that, on their respective long experiences, they had never seen a discounted market sale offer provided as generous a discount as that which the appellant now proposes. Ms Fitzgerald properly accepted it could be characterised as truly unique. 11 of the 23 units will be offered at a rate that is some 50% lower than that which will be required under national policy to qualify as affordable. The sheer scale of that discount and the extent of the assistance that it will provide to real families in Surrey Heath cannot be swept under the rug by acrid debates about the proper interpretation of CP5. Thirdly, as Mr Garside identified, the express purpose of the extent of that DMS discount is to produce rough financial equivalence with the social rented and intermediate tenures preferred by the Council as regards both the price with a set registered provider would pay for those units on the market and the rough figure which a social rent tenant would be paying monthly through mortgage repayments. Ms Fitzgerald sought to downplay that aspect of the offer for reasons which remain somewhat opaque, but it is critical when one comes to consider the deliverability of the affordable offer against alternatives involving RPs, which is considered further below. The challenge to the appellant's evidence on affordable housing has emerged through this inquiry through 2 very different paradigms. The Council has focused its fire on a series of form over substance arguments rooted in local policy which do not stand up to scrutiny. You, sir, have, however, raised what is indisputably a more important and carefully focused query relating to the reasons why the affordable housing offer on the scheme differs from that in the Golden Rules. The answer to that query was provided by Mr Garside, whose evidence is essentially entirely unchallenged. Each of those separate stands is taken in turn. The Council's concerns first. There are 2 basic limbs to the Council's case. First, that the discounted market sale housing offer by the appellant would not meet demonstrable unmet borough need. Second, that the DMS housing would lead to conflict with policy CP5 in terms of tenure. It's important to observe at the outset that both objections are remarkably short-sighted in their approach. There is no realistic doubt as to the need or scale of the affordable housing crisis in this country, all the more so in affluent Surrey Heath. Every single affordable dwelling offered should be treated as a benefit. The council's approach was identified in opening as a colossal failure to see the wood for the trees. That remains the case. The council's stance on this appeal is that because the affordable homes offered are not of precisely the type identified in a painfully out-of-date local plan, it's better to have none of them and to refuse the scheme altogether. A clearer example of cutting off one's nose to spite one's face is difficult to imagine. The objections, are also without merit on their face. Mr. Bolton's evidence puts pay to any suggestion the affordable housing offer would not meet demonstrably unmet borough need. As he has demonstrated, the 40% discounted market sale units offered would enable over 2,500 households within Surrey Heath to become homeowners where they would not otherwise be able to do so. The number is almost 7,500 for the 70% discounted market sale units. That is an obviously significant benefit, regardless of whether those homeowners are reliant on benefits or not, as Ms Fitzgerald appeared to take as her paradigm. Ms Fitzgerald also crucially accepted that promoting home ownership was an objective of national policy. The fact that other socio-economic groups may also require affordable housing provision within the borough, not met by this scheme, is hardly the appellant's fault. It is the fault of consistent under-provision on the council's part. On top of all of the above, and despite the council's unfathomable initial reluctance to accept it, the Section 106 agreement will secure an income gap on DMS products, limiting their accessibility to those who genuinely do need it. In light of that, quite how Ms Fitzpatrick maintains her argument that demonstrable unmet borough need would not be met by the DMS offer is unclear. In examination in chief, she continued to rely on the tenure split identified in the adopted plan. She has, in so doing, entirely failed to explain how her reliance on the plan, as reflective of borough need, is consistent with her acceptance that it's painfully out of date. The housing need figure in the adopted local plan is little more than a random number plucked from thin air insofar as its relationship to the current need is concerned. As to Ms Fitzpatrick's second objection, which relies squarely on the wording of CP5, the problems are even more manifest. The point being made appears to be, with respect, a rather crude one, namely that because DMS is not identified within CP5 as being one of the types of tenure which the council will seek, conflict arises and the whole offer should be rejected. There are at least 7 difficulties with that point. First, it alleges conflict which was not within the reason for refusal. As such, even from the members upon which this whole appeal rests, there is no authority to take that point. Secondly, as already indicated, it seeks to rely upon a policy test within a local plan which is agreed to be painfully out of date, chiefly because the housing need figure upon which policies, including CP5, proceeds, bears absolutely no relation to the reality of the position. Third, as Mr Henderson explains, at the point at which the policy was drafted, the DMS units now provided would have been regarded as caught by the definition of intermediate, which appears in CP5. The framework's definition, which appeared only a month later, reflects that, including, on its face, low-cost homes as a form of intermediate housing. That, on its own, is sufficient to deal with Ms Fitzgerald's argument. Once one understands that CP5 was in fact envisaging DMS units as an acceptable form of affordable housing on its face, even her narrow point falls away entirely. Fourth, and even ignoring the point on its face, the social rent to intermediate split to which CP5 adverts is specifically expressed as a borough-wide ambition, not a site-specific requirement. Ms Fitzgerald appears to have ignored this entirely in seeking to suggest that policy conflict arises within the scheme at a site-specific level as a result. Fifth, and again, even taking it on face value, CP5 expressly accepts that viability constraints may permit for departure from the policy on a case-by-case basis via the following caveat. In In seeking affordable housing provision, the Borough Council will assess scheme viability, including assessing the overall mix of affordable unit size and tenure, other development scheme costs, and any housing corporation grant subsidies secured. As such, even taking the policy on its face, it does not adopt the blanket and unflinching social rent intermediate split upon which Ms Fitzgerald's entire argument rests. Sixth, the policy expressly recognises that the exact viability issue is likely to be particularly acute in the context of extra care schemes, recognising that in such cases it may not be reasonable to seek any affordable housing contribution at all. As paragraph 5.31 of the supporting text very presciently explains, whilst the policy applies to all residential development, it's recognised that it may be difficult to provide affordable housing in private retirement homes, sheltered accommodation and extra care schemes. For such schemes, the Council will, on a case-by-case basis, have regard to the requirements of registered social landlords in considering whether it's reasonable to seek affordable housing. Ms Fitzgerald's blanket approach has had no regard for that important caveat. Seventh, as Mr Henderson identified, CP5 must be read with CP6, which specifically identifies that the Borough will promote a range of housing types and tenures which reflect the demand for market housing and need for affordable housing, and that while intermediate and social rented units are the expectations can be made on a site-by-site basis. Evidence of housing need or viability suggests otherwise. Again, on the face of the plan, it is therefore just wrong to suggest that a sharp 50-50 split between social rented and intermediate housing is required. The Council's objection on the affordable housing issue is therefore just wrong. So your query, the far more pertinent point identified by you at the outset of the inquiry, is simply why, given the scheme is otherwise entirely concordant with national policy, which would render it appropriate development in the Greenbelt, it's not able to provide a Golden Rules compliant level of affordable housing. The main but not sole answer to that question is provided by Mr Garside. His evidence in short is that from a viability perspective, that question approaches matters from the wrong end of the stick. The point is not that the appellant should have provided more affordable housing to take advantage of the Golden Rules, but that it is remarkable that it has provided any affordable housing offer at all, particularly one of such generosity when one considers the extent of the discounted market sale discount in play. Mr Garside's evidence on the viability of extra care schemes such as this is stark. It closely reflects the evidence provided to Inspector Stevens at Sonning Common, which led the inspector to conclude that extra care undoubtedly operates in a very different market, such that, as a matter of fact, age-restricted developments and in particular extra care communities are less viable than traditional housing schemes. The only difference between then and now is, unfortunately, as Mr Garside explains, the viability position has worsened. The critical feature of IRC schemes, which render them particularly challenging in viability terms, are as follows. First, construction costs, which are a particular pinch point for extra care schemes and which have skyrocketed in recent years. They are particular pinch points because of the significantly higher level of on-site facilities provided by IRC schemes in comparison to general housing, and because of the need to include specialist facilities within homes such as adapted bathrooms and kitchens, lifts and underfloor movement sensors. Mr Garside's unchallenged evidence is that bill costs for IRCs in Surrey Heath are likely to be in the region of 82% higher than they will be for general housing. The result is that any increase in construction cost industry-wide affects the IRC sector with particular ferocity. No clearer demonstration of that could be provided than the position at Sonning Common itself, where even in the last 5 years, bill costs have increased by 49% compared with a 12.5% increase in value. The second such feature is design efficiencies, as a consequence, again, of the significant provision of care and well-being related facilities, which are not themselves value-generating. Mr Garside's evidence, again unchallenged, is that the net-to-gross efficiency of IRC schemes is in the region of 25% lower than for traditional housing, which when combined with the bill cost already identified, can mean that the total costs of 100 square metres IRC unit is in the region of £560,000, over £560,000 compared to £233,000 for a similar sized traditional house. The third is sales rates, as Mr. Garside explained, for obvious reasons, given the magnitude of the decision that moving into an IRC represents. For most older people and their families, sales rates for such units are significantly slower than for a standard residential product. That additional sales period inevitably generates extra costs, which do not appear to have been taken into account in the Council's commissioned assessment for the purpose of the local plan. That is surprising, given, as Mr. Garside indicated, sales and marketing costs on the IRC scheme are typically double those on a standard residential scheme. The fourth is empty property costs. A further consequence of the importance of the decision to move into an IRC for the person concerned is that schemes effectively have to be built out in full before any significant sales can be expected. Between the point at which construction is complete, therefore, and the sale of each unit, the appellant incurs significant empty property costs in the form of general upkeep, cleaning and council tax. In addition, the appellant incurs proportionate service charge costs for each empty unit, which, prior to any sales, is a very significant figure. All of those very significant differences come on top of immense difficulty faced by IRC operators in securing viable land in the first place. The sharp reality is that they cannot compete with traditional volume house builders in this regard because the land value which they achieve is inevitably far lower as a result of the viability issues already identified. Mr. Williams' evidence was stark in that regard. Traditionally, the solution to that issue was for IRC operators to seek out greenbelt sites where competition from developers was lower. Now, in a greybelt era, even that slight advantage has fallen away entirely. Drawing those threads together, therefore, on the unchallenged evidence before this inquiry, the remarkable aspect of this scheme is not that it has failed to meet the golden rules, but that it has come close to meeting them at all. Mr. Garside's long expertise in the sector lends particularly great weight to his evidence that most age-related schemes are unable to provide any affordable housing contribution at all, irrespective of what development plan policy requires. That is the short answer to the central question as regards affordable housing in this inquiry. There are, however, two further important points to be made as to the affordable housing issue, which provide yet further context to the reason that the appellant has arrived at this inquiry openly accepting the golden rules are not met. The first relates directly to deliverability. The impression painted by the council of the appellant throughout the inquiry has been of a developer seeking to shy away from its responsibilities as regards affordable housing, with no real interest in actually seeking to improve stock within the borough. The opposite is true. As Mr. Garside explained, if the scheme were to come forward with golden rules compliant levels of affordable housing and full development plan compliant tenures, the prospect of identifying a registered provider willing to take on the management and maintenance of such a small isolated group of affordable dwellings is minimal. His unchallenged evidence is that there is no realistic prospect of that changing in coming years. Indeed, that difficulty is expressly recognised even within the extremely dated local plan, as was explored within Mr. Fitzgerald in cross-examination. As a result, the reality is that a golden rules compliant scheme would be far less likely to result in affordable homes actually being delivered, and would inevitably also result in the overall IRC units being prevented from occupation and held up in the meantime. Instead, the offer from the appellant is a deeply pragmatic one. By offering DMS housing at a significant discount, the appellant can ensure that affordable housing to the maximum level that can feasibly and viably be delivered as part of the scheme is secured, but crucially also that they will actually be delivered, sold to the market, benefit real people within the borough who need help in getting onto the housing ladder without waiting for RPs, which simply is not going to arrive. In 2026, that is just not a plausible outcome for an IRC scheme delivering golden rules and development plan compliant levels of affordable housing. The above is that the position, if the scheme presently before you, sir, is assessed on its merits, which is plainly the proper approach. The appellant contends that, in light of the unchallenged evidence of Mr. Garside, the The only proper conclusion is not only that the affordable housing provided should be regarded as a benefit, but a benefit to which significant weight should be afforded in the planning balance. Housing land supply, it is no exaggeration. I'll just say on that, we're both giving it significant weight, both parties, and yet we've explained all the benefit, and the council have continually sought to diminish it, which does really, I think, reveal something that sometimes when local authorities and their witnesses say they're giving something significant weight, they don't actually mean it. That's the problem. They say these things, it avoids an apparent confrontation, but then spending the inquiry seeking to diminish the value of that and seeking to downgrade the value by undermining it, seeking to say it's not what's required, etc., etc. So the key here, I think, is, who actually means it when they say they're going to give it significant weight. You say moderate on the, that's in terms of the,
on
affordable. Yeah. Housing land supply. It's no exaggeration to describe the current housing land supply position in Surrey Heath as shocking. It is agreed between the parties that the council cannot demonstrate a 5-year housing land supply, but that it is just the tip of the iceberg. It is, in reality, agreed that whatever the present figure is, the shortfall is a very significant one. At best, the figure tops out at barely 3 years. Great weight is placed by the council on the ability of the emerging local plan to remedy the situation. But as was explored with Ms Fitzgerald, the plan starts from a housing need figure, which is barely a third of the true need figure under the standard method. How, that being so, can the council begin to seek to address the needs of real people within the borough who are in need of housing with such a vast shortfall if their golden ticket solution starts from a premise so utterly divorced from reality? For the purpose of this appeal, however, the critical question is the extent of the council's current shortfall. As the inspector quite properly observed, the difference between the two parties' position and the range available is a relatively large one. It is, in that context, surprising to say the least that the council have filed no actual evidence to justify their claimed position. It is necessary briefly to explore the consequences of that. For the appellant, the evidence in support of the 2.24-year supply figure is provided by Mr Pycroft. His evidence was provided in the form of a proof of evidence. He was called to give oral evidence to the inquiry. His evidence could have been tested by cross-examination. It attracts maximum weight as a result. For the council, no witness offers any evidence on housing land supply at all. Ms Fitzgerald freely accepted that she could be of no assistance on the disputed points. The only material for which the council can point is the commentary offered in the Scots schedule. That is not evidence offered by an expert witness. It's not actually, in any real sense, evidence. It is little more than a rephrasing of information already contained in the council's published strategic land availability assessment. It has not been presented to the inquiry by anybody. It cannot be tested under cross-examination. The weight to be afforded must be substantially reduced as a result. Taking those two positions together, therefore, the reality is that Mr Pycroft's evidence is effectively unchallenged as regards the two outstanding areas of dispute. The first relates to whether the council is correct to reduce its identified need figure by 41 across the next 5 years due to the commitment made by Hart District Council in its local plan to meet 731 dwellings from Surrey Heath. Plainly, the council is not correct to do so. Hart's position is abundantly clear. All of that excess requirement has already been met in the periods of 2024, i.e. before the agreed base date for calculating housing land supply on this appeal. They have reflected that position by proposing a main modification to the emerging local plan to that effect and by making no modification to their own housing land supply calculations on account of the 41 dwellings per annum. That all being so, endorsing the council's position on this appeal risks 41 dwellings per annum simply falling between the cracks of both authorities' positions without justification. Hart have provided clear evidence for their position. The council have produced none at all, nor have they sought to challenge the assessment of Mr Pycroft, who comes down on Hart's side of the argument. The second relates to the failure on the Council's part to provide the necessary evidence as a matter of national policy to justify the inclusion of a series of sites within their deliverable supply. Mr Pycroft has explained his position clearly and cogently in relation to all 7. The Council has provided next to nothing in response. A summary as to why the appellant contends that Mr Pycroft's position is correct is set out in appendix to these closing submissions. The combined effect of Mr Pycroft's evidence on those 2 disputed issues is that the Council's housing land supply position is even worse than it has suggested, as a housing land supply of just 2.24 years is the true position. Against that background, it is entirely unsurprisingly agreed that the contribution of 187 units through the scheme to that shortfall should be afforded substantial weight in the planning balance. Custom and self-build housing, the appellant further contends, through the evidence of Mr Moser, that significant weight should be afforded to the contribution made by the appeal scheme of 10 custom and self-build plots. The Council, through Ms Fitzpatrick, signed a statement of common ground which agreed to that position in 2 separate places. In her oral evidence, however, Ms Fitzpatrick recanted from the statement, inviting you, sir, instead to place only moderate weight on the contribution. The sole basis upon which she sought to do so was that the contribution of 10 plots was, in and of itself, modest. For the reasons identified by Mr Moser, that is unsustainable, not least because it ignores every single one of the 18 appeal decisions which he cited, in which inspectors have placed significant or substantial weight on the provision of custom and self-build plots, including for very small single and double plot schemes. The critical aspect of the unchallenged evidence of Mr Moser are as follows. First, the Council's own evidence base positively asserts that Surrey Heath possesses one of the highest levels of self-build demand in the country. Second, that is supported by the registered data. There is a current Part 1 register demand accumulated over 10 base periods worth of inaction by the Council of 503 plots. By law, the Council is obliged to grant permission for 499 of those 503 plots by the 30th of October 2026. Third, that figure is highly likely to be an underestimate. There are 2 aspects of that. First, the Council has adopted a gamut of measures which remove individuals from Part 1 of the register, not because they no longer wish to take advantage of a CSB plot, but for unconnected reasons, such as a failure to pay a register retainer. That is not to say that the Council is not entitled to introduce those measures, merely that they result in the register figures underrepresenting demand. Second, the secondary data identified by Mr Moser and accepted by the Council to be relevant clearly indicates a higher level of demand. That is particularly so in respect to the build stall data, which, as Mr Moser explained, provides customers with far more actual value than simply languishing on the register in an authority which has shown absolutely no indication of wanting to address the demand. Fourth, the supply position is awful. Mr Moser, again, unchallenged evidence is that just 12 properly secured custom and self-build permissions have been granted since the inception of the register, comprising just 25 plots. The accepted shortfall is therefore at least 474 plots, with the Council having failed to comply with its statutory duty in 7 of the last 8 base periods. Fifth, there is no other mechanism by which the shortfall could even plausibly be addressed than through schemes like this, which offer CSB plots on a windfall basis. Ms Fitzgerald has, it seems, spent the inquiry proceeding on the erroneous basis that the adopted development plan contains a policy mechanism to meet that CSB need. It does not. That may go some way to explaining her downgrading of the weight to be afforded to the 10 CSB plots as part of the appeal scheme. Sixth, the consequences of the scheme are of real benefit in addressing that shortfall here and now. Most importantly, the 10 plots provided would, on their own, address 100% of the need arising from base period 8, which must be met by the 30th of October this year, and would represent an increase of 40% in supply of plots in Surrey Heath compared to the performance over the last decade. Quite how, in that context, it can be appropriate to downgrade the weight afforded to moderate escapes the appellant. For those reasons, it's clear and obvious that significant weight should be afforded. Sang. A further benefit to which the appellant contends substantial weight should be afforded is the provision of an 8.6 hectare SANG in respect of a scheme which only requires 2.8 hectares of SANG to mitigate its own effects. That leaves the provision of a 5.8 hectare of excess SANG, which the appellant contends is a clear benefit. That is most obviously so because it is sufficient to support the delivery of some 302 additional homes across the borough and to benefit 350 existing households who do not presently have access to high-quality open space. Ms Fitzgerald disagrees. Her evidence, despite not mounting a challenge of any of those basic facts, is that the SANG is not, in fact, a benefit at all, on the basis that any benefit of spare SANG capacity will be limited to developments within 400 metres of the site because no SANG-specific car park is proposed, and the size of the SANG is a result of the need to make it functional under Natural England guidelines, but any more general benefit, and the council can already demonstrate sufficient SANG capacity through the borough to meet its statutory targets for future housing development. None of those three withstand analysis. Point A falls for two reasons. First, the fact the SANG may only be able to serve a more limited range of future development with the same area is no reason to say that it's not a benefit at all. Plainly it is, even if the number of future residents which might be served is smaller than it might otherwise have been. Secondly, the scheme is presently at outline stage only. If, in the future, an 8-space car park were to be a feasible option, it could easily be accommodated within the extensive available space on the appeal site. In the meantime, despite the line of cross-examination pursued with Mr Henderson, it is indisputable that the scheme does not require a car park to be compliant with Natural England guidance because it is intended for local use only. Point B falls because it confuses the motivation of the appellant with the materiality of the benefit. The precise reason why 5.8 hectares of excess SANG is being provided is neither here nor there. The fact is, it's being provided and must be assessed as a benefit as a result. And point C falls because it ignores entirely the existing residents who benefit from the SANG, numbering some 350 households, the benefit which they will derive from it entirely unconnected to the council's stock of SANG in the future. That's particularly true of the elderly residents residing within the scheme for whom doorstep access to such high-quality open space will be of immeasurable real-world benefit. Overall, therefore, Ms Fitzgerald's attribution of neutral weight is not justifiable. GP surgery. The debate as regards to surgery is between significant weight on the appellant's part and limited weight on the part of the council. By way of context to those weightings, the following is all agreed and unchallenged by the council. At present, the 4 GP surgeries local to the area are operating over capacity by some 3,505 patients. No evidence has been presented by the council, the IBC, the surgeries, or any other party or witness to this inquiry as to how that shortfall is going to be met. B, the appellant proposes to provide service land for the construction of the surgery for a nominal sum, which would otherwise cost the NHS in excess of £1 million of taxpayers' money. Given the scarcity of sites within the local area, the reality is that the figure is likely to be closer to 1.5 million. C, the most up-to-date position of the surgery who would most obviously benefit from the offer is that it is incredibly helpful, and the most up-to-date position of the ICB as statutory consultee is that it is a significant opportunity for long-term healthcare provision. The appellant has been engaged in constructive discussions with the ICB throughout the application process, of which those updated positions are the direct product. Ms Fitzpatrick has not spoken to or even attempted to contact either the surgery or the IBC to seek to explore why they have made such positive statements in support of the proposal if her concerns about deliverability are correct. The sole basis upon which Ms Fitzpatrick seeks to downgrade the weight to be afforded to the offer is trailed in what she describes as considerable uncertainty around delivery. In so doing, she seeks to rely on what are said to be caveats within the ICB's most recent response and recent experience in the form of a failure by the ICB to take up the opportunity of a surgery offered at Orchard Cottage. Neither stands up to scrutiny. As to the first, the caveat in question is the indication by the ICB that the delivery of the surgery will be subject to patient engagement and financial considerations. That is obvious. It's not a caveat, it's a reflection of the fact the appellant cannot simply ignore the NHS's internal funding and consenting processes in seeking to provide a workable, innovative solution to the borough's deficit in primary healthcare provision. As Mr Donner explained, the appellant has directly responded to those concerns by securing through Schedule 4 of the Section 106 agreement an extended period of time for which the offer of land will remain open, some 10 years, to enable those processes to take place. As Mr Henderson explained, that was a consequence of direct negotiations with the ICB themselves, in stark contrast to Ms Fitzgerald's failure even to attempt to contact them. It is in light of that offer that the ICB, who are far more familiar with the likely outcomes of those processes than Ms Fitzgerald, have described the offer as, and I quote, a significant opportunity for long-term healthcare provision, and provided their formal support for the scheme. The Council's response is an unconvincing attempt to second-guess the knowledge of a statutory consultee of its own internal processes without even bothering to attempt to contact them and speak to them about it. As to the second issue raised, the short point is that the Orchard Cottage situation is in no way comparable. It relates to an outline planning permission granted in 2015, some 11 years ago. The Council has filed no evidence as to the comparable state of the shortfall in GP provision at the time. By 2021, the point in time at which Mr Fitzpatrick states the ICB failed to take up the opportunity of a site with planning permission for a surgery, the Council had no input or feedback from the relevant NHS authority. They did not provide a consultation response. It is furthermore expressly recorded within the minutes of the meeting that the surgery was not actively requested by the Council on the 2015 permission, and that the NHS has been chased several times for a response but not provided one. That stands in stark contrast to the current position, where the relevant NHS authority have actively engaged throughout and have provided their clear and positive support for the scheme. There is, as such, no real comparison between the two situations at all. That being so, Ms Fitzgerald's objections fall away, and it's plain that Mr Donner is correct to afford significant weight to the provision of the land for a new GP surgery. Health and wellbeing benefits. There appears to be dispute between the parties about the extent of weight to be afforded to the health and welfare benefits for the residents of the IRC. Mr Henderson contends that the weight should be substantial. Ms Fitzpatrick contends that it should be significant. Ms Fitzpatrick offers no evidence as to why her rating is lower, and actively acknowledging that the PPG compels the offering of a high level of weight in those circumstances, quite apart from the evidence he has produced to the inquiry which supports that position empirically. In light of the evidence of Mr Donner and Mr Williams in particular, it's clear that substantial weight is appropriate. The IRC product is a unique offering amongst the specialist housing sector. It benefits from clear evidence derived from academic studies lasting many years of an improved quality of life, improved well-being and mental health, and a reduced likelihood of visits to GPs, hospitals and long-term care facilities. It is easy to discuss facts and figures as regards specialist housing, which this inquiry has done at length, but those cannot be allowed to draw attention away from the very real and very tangible benefits that will be provided to older residents of Surrey Heath and their families as a result of the scheme. That will also have a knock-on economic effect. Mr Donner's evidence, again unchallenged, is that the health and well-being benefits will result in total savings for the NHS and local care services of a minimum of 1.4 million per annum. Release of family homes. It's agreed between the parties that further moderate weight should be afforded to the release of family homes back into the open market as a result of the scheme. That is plainly appropriate given the housing land supply position outlined by Mr Pycroft. It should not be underestimated as a result, however, in the midst of a national housing crisis, it is a huge real-world benefit to consent a scheme which frees up large family homes without actually having to build those homes to begin with. As Mr. Williams identified, recent research indicates that if all homeowners across the UK aged 65 who wanted to move were able to do so, some 2 million spare bedrooms would be freed up countrywide. That is a huge benefit in its own right. Economic benefits. Whilst they have received less focus during the inquiry, there is very good reason that national policy dictates that affording of significant weight to economic benefits of development a policy imperative with which the scheme chimes in full. Those benefits are unchallenged. They include the provision of 85 full-time jobs during construction with associated gross value added of £33 million. The provision of a further 30 permanent full-time equivalent positions to staff the village during its operations with an associated gross value added of 1.2 million annually and local spending by residents in the order of 6 million per year. Other benefits, all of the above, must be added to a number of yet further benefits existing and weighting of which is agreed. Moderate weight must be afforded to the provision of 10% BNG. Limited weight must be afforded to the investments to be made by the appellant in local transport infrastructure, including the provision of a footpath along Snows Ride, with, in the appeal site, a scheme to reduce the 40-mile-an-hour speed limit along Snows Ride, and improvements to the junction at the A30, all of which are designed to respond to local concerns about highway safety in the immediate vicinity. Limited weight must also be afforded to the benefits of the mixed intergenerational community which is to be created on site, encouraging intergenerational interaction. Very special circumstances. Balancing the harm by reason of inappropriateness and other harms against all these benefits, plainly planning permission should be granted. That being so, there is no strong reason to refuse, that should read to refuse, and the tilted balance applies, albeit that is largely unnecessary. And in conclusion, for those reasons, the appellant respectfully invites you, sir, to allow the appeal and grant planning permission in the terms sought. There's an appendix to which I don't refer, but can I just make very briefly, about 2 or 3 minutes, a couple of points on the friend's closing submission. He referred to a 1.5 kilometre walk. That is not correct. It's a 2 kilometre walk. It is just short of the, I think, 2.2 or 2.4, but it isn't 1.5, and that would be an error. Paragraph 2, it says the council's case is that the tilted balance is disapplied in this case. The tilted balance in the MPF, paragraph 11D2, not D11D as a whole. In this case, it's agreed that development is appropriate development and may not be permitted. And I think he added the suggestion that people don't always understand that. Well, I can tell you we do understand it. The tilted balance is only that which appears in 11D2. We've never contested otherwise. My witness is absolutely clear about that. And it was indeed me that answered questions on this in the Supreme Court in the Richborough case. If you don't believe me, watch Supreme Court TV. We have never had any doubt about that. The answer lies in the very special circumstances, because it just makes it odious, really, to have to go down that route. But we've done it and we've identified it. The difference between the parties is the council don't think very special circumstances exist. And if that is right, then the green belt is a strong reason not for granting planning permission, and in those circumstances the tilted balance doesn't apply, but that isn't our case. Just very briefly, paragraph 27, Mr. Henderson's assertion that the degree of activity would be relatively low compared with the proximity to the A30 is not credible. It is credible because when you look at activity, you don't do so in a vacuum. The activity on a greenbelt site must be seen in the context of the development around it, and that includes the A30. So I'm not going to rebut every point. Urbanity, I think we're gracious enough to accept that it isn't urbanity. It is, hopefully, a gracious and sophisticated development. But yes, it is right that we are referring there, of course, to the urban nature of the surrounding area. And then finally, paragraph 43, the suggestion about the affordable housing, it might have justified a sum in lieu of the affordable housing. I don't think that formed any part of the council's case to suggest that somehow we should have provided a money in the alternative solution. But of course, when you do provide in lieu sums, that doesn't buy you the land. So you need all the land in addition to whatever the contribution is. The appellant's proposal is far, far better than an in lieu payment. Unless I can assist you further, those are our submissions.
Thank you, Mr. Young, and I suspect also Mr. Henderson in production of that closing submission. So thank you very much. Okay, thank you all. I do appreciate the effort that's put into closing submissions. It does help me in drawing together all the various threads that we have been hearing about over the last 2 weeks. So thank you for the efforts for both sides in doing that. Appreciate you did indicate that there weren't going to be any costs, but I just need to ask both parties, are there any applications for costs? In which case, other than for the Section 106 agreement to the timescales that we've already talked about, I'm not intending to take anything further once I've closed the inquiry.
So, sir, just before you do that,
yes.
just wanted to update you as to what's been happening during closing. The TRO obligation.
Just bring it towards you a bit.
Sorry, apologies. We have got agreement this morning from both the County Council and the Borough Council for the split that we talked about at the opening.
Yeah.
That new TRO condition has been dropped into the schedule of conditions.
No,
and
I've got a version 7 copy just handed to me.
And one's gone to PINS as well this morning.
Thank you.
The new obligation, which is Schedule 9, which is to meet the costs of the TRO, has been dropped into the 106.
Okay.
And a copy of the final agreed form has been sent over to PINS this morning to the case officer.
That's very helpful. Thank you, Mrs. Burgess. Okay. In that case, before I move to close, is there anyone else wants to say from the council's point of view? Appellant's point of view?
I just apologise for referring to Ms Fitzpatrick as Ms Fitzgerald.
Well, it's entirely my fault because I probably put that in your mind, so I do apologise. Oh, yeah.
You don't have to be called Fitz to work in planning.
Okay. Well, can I say, if there are any further questions or comments, I'd like to thank you all for your help. You've certainly given me food for thought, which I shall now go away and ponder on. So I hereby close the inquiry and wish you a good, a pleasant rest of the week and good weekend. Thank you.